Court in session. Good morning. Please be seated. This is the time set for oral argument in State against AZTECA. Our cause number is 1CA CV160300. Counsel, I'm sure you're familiar with the proceedings here and know that we have conferenced the case, understand the briefs and the record, so bear that in mind as you begin your presentations. We will be audio and video recorded today, and that recording will be made available online. Each side has 20 minutes for oral argument, and the appellant has as much time for rebuttal as you wish. Just watch your own clock, and with that, we can begin.
Good morning and thank you. I'm going to try and save about 5 minutes. Historically, it hasn't worked out that well, but I will try. Good morning. My name is Clifford Shear. I am the attorney for the appellant, Bankers Insurance Company, and AZTECA bail bonds. I stand before you today because I refused without a fight to allow a trial judge to gut this court's decision in State versus Old West bonding. What happened in this case was that Judge Pro Tem Nothwer decided that because the defendant missed a court date and left the state without permission, that justified the forfeiture of the entire $75,000 bond. When I pointed out to the judge, both at the original argument and through my motion for a new trial, that State versus Old West bonding requires you to look at all kinds of factors, that was completely ignored. He completely focused on the fact that, the defendant missed a court date because he had gone to Texas and then had to serve a little time there. But we brought him back. When I say me, I mean through the cooperation of the state. He was standing in front of Judge Nothwer at the time of the bond forfeiture hearing.
And that's the fact that your client helped bring him back is a persuasive factor. But let me just lay out competing considerations. You make persuasive arguments about the interests of your client, given its efforts essentially on the state's behalf. There's also, I think, a fairly compelling public policy that would suggest that the loss of the bond is supposed to be a disincentive to leaving the state, to not showing up at your court appearances. And the bond is calibrated when it is set to have a deterrent effect for the circumstances of the individual defendant. So that policy might very well weigh in favor of the trial court's decision. Your arguments weigh against it. The trial court could have gone either way, and this is an abuse of discretion case. So how do we untie that knot?
Fair enough. The way you untie it is what I cited in my brief, undisputed by the state, that the case law, and admittedly there's none from Arizona, but the case law that I've cited indicates that when a court is obliged to make a discretionary decision, that the court is obliged to look at all of the factors.
Is there some suggestion that the court didn't look at the factor? If the court just decides, I'm not going to give it as much weight as the party would like me to give it, that's a different, I mean, it's a tough argument for you to make unless the court says, I'm not going to consider that. It's hard for us to say the court didn't take account of what was presented.
Well, to that remark, I have two things to say. Number one, if you read the both the original determination of Judge Nothwer and the one he wrote to try and justify the original decision, written in response to my motion for a new trial, which he summarily denied, he seems to be focused solely on, well, gee, you left the state when you shouldn't have. Okay, there's no discussion about any of the other factors. And I would also point out that Judge Pro Tem Nothwer forfeited the entire bond. Okay, he did not find one centavo of mitigation in all of the work that we did in getting Mr. Williams back in front of the Maricopa County Superior Court.
That raises an interesting question. From your perspective, he should have been looking at the work you did. Is it not also legitimate to look at the consequence that forfeiture of the entire bond has on the defendant? Because ultimately, I assume this bond was secured, and it's the defendant who's out of luck.
Not necessarily. You see, and I've been doing this for a long, long time, as my gut and gray hair will testify to, but it's generally a family member that gets stuck losing their house.
But it's not your client.
Assuming that the collateral is good, then yes, that's true. But if the collateral is shaky, it's my client too.
Which is that your client posted the bond based on thinking the collateral was good.
I would hope so. It's not always the case.
Risk of doing business.
Yes. Okay. Another issue I would like to raise, and it is in my brief, is the idea, and Judge Schwann touched upon it, that, $75,000, it was set at the beginning for any number of reasons, one of them being a deterrent factor. And I would argue that if the defendant disappeared, okay, he was in the wind, he could never be found, he went to Mexico, whatever, that sum would be a perfectly legitimate amount to forfeit. However, in the situation where the defendant has been brought back, I have argued that that penal sum is akin to a penalty in a contract, and that.
Would you also agree that you might factor in how long it took to get him back? If he comes back 2 days after he was supposed to be there, maybe that is given more weight by the trial court.
Sure. That is one of the factors listed in State versus Old West bonding. The prejudice to the state, sure, because witnesses die or they forget and things like that. The longer this goes on, that could prejudice the state. I will tell Your Honor that in this case, the only evidence was that there was no prejudice to the state, and that the 1 year hiatus, didn't seem to bother anybody. They just picked right up where they left
Pretty
off.
hard to argue zero prejudice. There's presumably discovery, things that can be done prior to trial.
All I can tell you is what's on the record, and that was that we argued, and there was no dispute, that there was no prejudice, and I specifically wanted to cover this because it is an Old West bonding factor, and I wanted to make certain that if there was going to be a problem, we would deal with it. But it was not disputed, and we took it as gospel. But yes, you're right. That could be, in certain circumstances, something that weighs against complete exoneration, or, as State versus Old West Bond puts it, how much or how little to forfeit.
I think you understand the challenge in making this argument on appeal. Are you suggesting that what would your argument be if the court ordered forfeiture of $50,000? And where are we supposed to come up with a number if it's an abuse of discretion standard of review? Is it necessarily, if it's $74,000, that would not be an abuse of discretion, but because he didn't lower it at all, that's the abuse of discretion?
I will tell you, Your Honor, that case is pending before the Supreme Court of Arizona on a petition of review, where $95,000 of a $100,000 bond was forfeited under circumstances not completely unlike this. And, you know, some sort of token gesture for me doesn't cover it. Obviously, as the amount exonerated approaches, you know, 4 figures or something on a $75,000 bond, I have less and less of a gripe. And the answer to your question is, you know, I don't know whether $50,000 would have cut it or not in front of this court. It certainly would have demonstrated some discretion. But in this case, what the court did is he forfeited the entire bond, notwithstanding all of the factors. As I say, I've got about 3 minutes left if I'm going to save my 5.
Well, let me ask you a question then.
Okay, go ahead. That's better.
I've often griped that the abuse of discretion standard is capable of so many interpretations that label can become almost meaningless. How would you define abuse of discretion in this context?
That has been done for me. And the cases that I have cited, if I may, here I am going to be citing Carijano versus Occidental Petroleum, 643 F. 3rd, 1216, 1231. Appellate courts have held that an abuse of discretion occurs when a trial court, quote, strikes an unreasonable balance of relevant factors when it makes a discretionary decision.
That sounds awfully de novo to me.
I'm sorry?
That sounds awfully de novo to me. Are we supposed to say he weighed the factors and came to his own judgment, but we think they're unreasonable?
Under Arizona law, a bond forfeiture determination is an abuse of discretion. I wish it weren't, but there it is.
I always wrestle with how to apply the abuse of discretion standard. I mean, surely it's something more demanding than blind deference, but sometimes it can be pretty close to that.
Sometimes, and believe me, I have seen that. All I can tell you is that, as I say, in this particular case, I believe that the judge wrongfully fixated on only one factor to the total exclusion of the others. And in addition, since bond forfeiture matters are contractual, contract principles apply. This court in 2013 when it ruled against me in State versus Liberty Bail Bonds, 233 Arizona 474, 314 P3rd 820, did say, though, that contract principles apply to bond matters, including, as far as I'm concerned, excessive damages, punitive clauses which penalize in case they're broken.
Of this contract, though, is that the entire bond is at risk. Wouldn't a penalty be, we're going to forfeit the bond and sock you for an extra $25,000?
No, I don't think that's the way it works.
But if you're talking about a contract, the contract was to have the person here, and if not, you forfeit this amount. So I'm not sure I follow that.
Well, the whole idea of State versus Old West bonding recognizes that the bondsman historically has had the opportunity to get the man or the defendant back, and therefore to mitigate his loss. And that's all we're asking for today. Now, I have 4 minutes and 40 seconds. I will answer any question that the court would like. That's more important.
If you'd like to reserve it, we are fine with you doing that.
Thank you very much.
Good morning. My name is Kim Felsen, and I represent the state of Arizona in this matter. I wanted to briefly touch upon some of the issues that Mr. Scheer raised in his remarks, and I know the court's read the pleadings. As the court's aware, in my answering brief, I had attached as exhibits the 2 separate minute entry orders that were generated by Commissioner Noteware about the factors that he took into consideration when making his determination as to what was appropriate. I do disagree with Mr. Scheer. If you look closely at the minute entry orders that he generated, he actually talks about multiple factors that he thought about and contemplated before issuing his order. He's actually very clear, particularly in the April 8th minute entry order. He talks about the defendant's mitigation information. So he was aware of what Mr. Scheer presented, and he indicates in his order that based on his balancing of the factors, that mitigation, while contemplated, fell short when compared to the significance of the public's interest in the underlying criminal case. The other issue I would really like to talk about is Mr. Scheer's characterization that there's just been absolutely no prejudice to the state. The bonding company conceded that this defendant was outside the jurisdiction for at least a year. The record does reflect that. If you look closely at the transcript, which should be part of the court's information, I actually say on the record to Commissioner Noteware that I was not aware if there has been prejudice to the state. Obviously, the case is not assigned to me to prosecute. But what I did say to Commissioner Noteware and to Mr. Scheer was that we knew that this case had been deemed complex by the trial judge, and that the case was pending in Maricopa County, and that there were multiple co-defendants. And it's clearly right here in the record. I state, I do not know if there has been prejudice to the state. And so when he makes these statements that there's been absolutely no prejudice, the state.
But how does the defendant show an absence of prejudice if the state doesn't proffer something in the way of prejudice? It could well be that the case is on the back burner and nothing's being done for reasons completely unrelated to this particular defendant. So what would he have to argue to show that there's no prejudice if the state doesn't come forward and say, yeah, we needed to interview this person, or we couldn't do something?
Well, I mean, I think that he would have to get some type of sworn statement or perhaps even an affidavit from the case agent or the assigned prosecutor saying, look, this is such a complex issue that we're grappling with that we actually can put Mr. Williams' case aside and focus on his co-defendants during this process. Or if Mr. Scheer had even gotten a sworn statement from the assigned prosecutor who had said, look, I understand your position. I think I understand what you're asking for. We're not dealing with Mr. Williams' culpability through our discovery process right now. We're dealing with the other co-defendants based on issues that aren't related to Mr. Williams' involvement.
Would you at least agree that the absence of any avowal of prejudice is a factor the court can consider maybe in the defendant's favor in making the bond determination?
Determination. Yes, Your Honor. I mean, if it was corroborated that there was absolutely no prejudice to the state, I think that the court could look at that and think that that would be a favorable factor for the bonding company.
Well, and I'm not being critical. You were candid on the record, which I commend, but the case for prejudice in this case is about as weak as it can get, absent an outright concession by the state, right? I mean, there are other factors, I grant you, but arguing prejudice at this point is probably not your strongest argument. Wouldn't you agree?
Yes, Your Honor, I agree. I think the state's strongest argument would be that under Rule 7.6 D2, the facts clearly show that the bonding company did not physically surrender the defendant. We know that my office generated a notice of writ under the CR number. So I think the state's strongest position is that we know that the court, Commissioner Noteweir, would have discretion to forfeit some of the bond, all of the bond, or none of the bond. I only bring up the prejudice issue because Mr. Scheer has no direct knowledge as to what the assigned prosecutor was subjected to, and it's almost like a blanket generalization with having no direct knowledge as to what the criminal discovery process was for the assigned prosecutor.
Would you be on other sides of the room if the commissioner had forfeited or had exonerated the entire bond? Would you consider that an abuse of discretion?
No, I would not. I mean, I take the position, generally speaking, that the court has that discretion, and if Commissioner Noteweir felt that entire exoneration was appropriate, that's the court's discretion. That's their role, and I don't think that it's my place to try to eliminate the discretion that's, afforded to them. And so the other part that I wanted to bring up was,
I assume the argument would be, unless the court didn't consider a factor, if the court excluded from consideration a factor that the state thought was important, just said, I'm not going to consider that, then
yes,
presumably the state would weigh in that circumstance.
Yes, Your Honor. And from my recollection, I don't think Commissioner Noteweir ever took that type of position. The minute entry orders that he generated made it clear that he not only reviewed the mitigation presented to him, but the trial file. He contemplated public policy and the extradition cost, which is all in the minute entry order. So when Mr. Scheer says, look, he just considered one factor, it's clear that the record doesn't reflect what Mr. Scheer believes.
And this may be in the briefs, and I may have just forgotten. Is it clear the reason for the incarceration in another state?
It wasn't clear initially. It appeared that initially, I believe Mr. Scheer believed that the defendant had left the jurisdiction. He did not have permission to do that, and then had subsequent drug charges. There was some determination of that.
Based on conduct that occurred after he left Arizona, or was it
I think that was initially what was believed, and then after that thought process, what was later determined is that it was a probation violation matter in the state of Texas. But I don't know that with absolute certainty. It's just if you look through the transcript, there was some determination that drug charges were made. new drug charges came up, and then after that, it seemed to be like, no, it appeared to be a probation violation issue of a matter that he had already been prosecuted for.
But there was no argument that he was wrongfully detained in Texas.
From my recollection of the transcript, no, that he had left the jurisdiction of Arizona, which Mr. Scheer doesn't seem to dispute, that was not permissible to do so, but he did. And then subsequent to that period of time, he ended up in the state of Texas. So I just wanted to, again, address that prejudice issue because Mr. Scheer stated on the record that it was undisputed by the state, and that doesn't seem to be accurate based on the transcript that I just referenced. And based upon what he's saying, it appears that he doesn't want Commissioner Noteweir to, excuse me. Sorry, I put my phone on vibrate. I apologize. And so it appears that Mr. Scheer wants to take that discretion afforded from Commissioner Noteweir when we're aware that he acknowledges that these courts have discretion. And just because we have a belief or good faith basis to believe that Commissioner Mata may have done a certain determination, that doesn't mean that Commissioner Noteweir wouldn't have the ability to do something that he thought was appropriate. I believe Mr. Scheer's fourth argument was, Commissioner Noteweir was told, well, Commissioner Mata usually handles these cases in this manner. And so therefore, he should have done the same. But that would, again, take away his ability to exercise his discretion.
Is it a factor that should be considered if there were a string of cases that could be cited that no one has ever forfeited the entire amount when the bond company returned?
Sorry, I'm shutting it off. I don't know why it's not. It's off. I'm sorry. I don't know why it's. I apologize, Your Honor. Could you repeat that, please?
I've already forgotten what.
If there was I think you said if there was a series of cases.
Yeah, if there were a series of cases that all said that this is that have never forfeited an entire amount if the bond company brings the defendant back and makes the effort to do that, and this were the only case out there, it would, understanding that it's an abuse of discretion standard, would that get to the level where we could say this is an abuse of discretion?
Well, yes. I mean, I think if the case law directly contradicted that, if there was a case that said, look, if you forfeit every penny of a bond, that could be deemed a penalty, well, then yes. I mean, I think the court would have no choice but then to recognize that that's what the case law was telling.
But each case has to be decided on its own facts.
Yes,
So
yes.
you're saying that, yes, if there was a case directly on point, it wasn't distinguishable, and it said you can't do this, then it would be an abuse of discretion. Is that what you're saying? Or are you saying that, is that what you're saying?
I'm saying that if it was a bond forfeiture matter and the factors were very similar to what was presented by Mr. Scheer's clients and the defendant, and if it was so directly on point that it could be deemed a penalty, then I think ethically the state would have no choice but to concede and be like, look, this case with Mr. Williams is so directly on point that I can't ignore it. I can't refute it or contrast it with what Mr. Scheer's arguing because it's not favorable to the state. But here, we know that the discretion is conferred upon these judicial officers and they have that autonomy. And if you look closely at what Mr. Scheer indicated, as well as what Commissioner Noteweir indicated, he did look at a multitude of factors. I mean, he listened to the indemnitor, he reviewed the trial file, he recognized that the criminal case was deemed complex, He knew how long the defendant was out of the jurisdiction. He recognized public policy issues. That he also, I know for sure, recognized that there were multiple victims alleged to be victimized in the indictment. So I think that the bonding company had ample opportunity to present its mitigation. I mean, there's been nothing from Mr. Scheer to suggest that he wasn't able to present everything that he felt was appropriate to present. But at the end of the day, the court looked at the mitigation and felt that it didn't outweigh the public policy concerns. So I think the transcript is very clear with that, and I think that the minute entry orders generated by Commissioner Noteweir, you know, he's creating a record. He's presenting what he contemplated.
About the second ruling, would the record be adequate in your view?
Yes, Your Honor. I think so, because when you look at the March 1st transcript, which again should be part of the record, that is the date that the indemnitor is present, and I briefly addressed the issue of prejudice, and that is all prior to the subsequent March 8th and the April 8th minute entry orders that are generated from Commissioner Noteweir. And so, yes, I mean, I think that, you know, he did want to hear from the indemnitor. He did so. He asked her financial questions about the financial situation if the bond was forfeited. So because that hearing occurred all before the subsequent minute entry orders were generated, I think the court can take the position that Commissioner Noteweir did contemplate what he thought was appropriate and made that, you know, the determination that he made. You know, this idea of discretion, you know, the bonding companies, they assume the risk when they bond these individuals out. They know that the individuals are out of custody. They know they have free will. They know that they have resources to leave the jurisdiction. And that's the risk that the bonding companies will assume, and that they do assume, you know, if the defendant, you know, leaves the jurisdiction and misses court. The other emphasis I'd like to make is because I think Mr. Scheer normally takes the position of, look, he's eventually back in the courtroom. We know that. The state would submit to the court that justice delayed in any factor is justice denied, especially when
He's not only asserting, look, he's back. The bond company actually makes the effort to get him back. It seems like that is at least something that should be considered.
Yes.
As opposed to them just walking away saying, sorry, he's not here, okay, forfeit the bond. Seems like we would want to encourage them to do that.
Oh, yes, yes, and I agree with Your Honor. And the record does reflect that Mr. Scheer made a record with Commissioner Noteweir telling him, like, look, we know he's in the state of Texas. I've conferred with Ms. Felsen. She's indicated to the extradition attorneys in her office, this is where the defendant is.
Does his ruling encourage other bond companies to do anything that would encourage them to do that undertaking? It sounds like it's just causing work for them, and then the whole bond's forfeited anyway.
Well, I think it wouldn't discourage them from trying to track defendants, because they always want to take the position of, look, I have this financial incentive to make sure that the defendant is in court for his hearings.
But what's the incentive? Because if the defendant doesn't show up the first moment and the state takes the position that the entire bond is forfeited, isn't that kind of self-defeating from the state's standpoint? Because eventually you just disincentivize finding defendants?
Well, I think, though, that if you look at each bond forfeiture case, a lot of them have such specific facts and fact patterns and in terms of what goes on, that it wouldn't be a disincentive, because at the end of the day, their objective is to make sure that these defendants are at least tracked or brought back to the jurisdiction, because then they have at least a good faith argument to be like, look, you may rule against me, but at the end of the day, Your Honor, I want you to see that the efforts that I've taken can be presented to you. But then that is the risk that they take, that the court could be like, look, I know your indemnitor's here. I know they have a financial concern, but we know definitively that a balance of, I just think that public policy affords the decision that I'm going to make.
Does the state ever take the position that only partial forfeiture is appropriate? Or does the state always argue for full forfeiture?
It depends on the fact pattern, but generally speaking, I allow the court to have the discretion.
The state doesn't take a position, on the amount to be forfeited?
No, Your Honor, not really, because I prefer the court to have that discretion. There have been unrelated cases where Mr. Scheer has asked me.
Well, when you ask for forfeiture, you must be asking for some relief.
Yes, Your Honor.
And don't you say, I think we need relief in the form of forfeiture of $75,000, or do you just say, do something about this, court?
I generally say do something, or it's up to the court's discretion. Mm-hmm. There have been unrelated cases where Mr. Scheer has asked, would you stipulate to an amount, or would you agree with me in my argument to the court? And I generally don't like to stipulate with any of the attorneys that represent the bonding companies. I take the position that the court has that discretion, and I might make an argument, or I could say, well, yes, forfeiture would be appropriate, but I never put a specific dollar amount because I feel like it's up to Commissioner Notweir,
Ever
Commissioner Mott.
Suggest that something less than the full amount would be appropriate?
Yes. If somebody has extreme financial hardship, I could take the position of, it sounds, Your Honor, like they've made a good faith basis that if the forfeiture was to occur, they'd have a financial hardship. Somebody might lose their car or as collateral or something of that nature. But I generally don't put a specific dollar amount as to what I think is appropriate because they have that discretion.
Okay. Thank you.
Thank you.
Good morning again. Just a couple of things. Number one, it was pointed out that Commissioner Northworth supposedly took Factor 6 of Old West bonding, which is the public interest factor, into account. And I pointed out, and I think this court was spot on today, that really the public interest that Old West talks about is to incentivize a bondsman to do exactly what was done in this case, to make sure the guy is brought back. Because as this court has recognized, if the ultimate result is that we're going to expend time and resources and whatnot to get the defendant back, and we're still going to have the entire bond forfeited, then yes, what's going to happen is the bonding community is going to throw up their hands and say, why bother?
Maybe the result would have been different if their efforts had borne fruit more quickly.
Yes.
I mean, the incentive might be, don't take a year to bring him back. Get him back right away.
I tried to reason with the state of Texas, and they were completely unreasonable. You serve every minute of Texas time and don't come to us a minute sooner. Oh, and by the way, be sure to be standing here when we let the guy out, because otherwise he's walking into the Texas sunset. We don't care about Arizona's, hold.
That goes to it's the punitive nature as against the defendant for leaving when he shouldn't have.
Yes.
So it does come down to the difficulty we have with an abuse of discretion standard when there are factors that support what the court did.
I am not arguing the point. The one factor and the one that he focused on was you weren't here, but unfortunately that is not the only factor discussed in Old West bonding.
You were here because you had a flat tire. You were here because you left the jurisdiction, wound up doing time in another jurisdiction.
Yes.
All of this was not accidental, and the return wasn't prompt. I mean, couldn't those factors, if You had the exact same facts, except the defendant was absent for a reason not of his own making, and the bonding company returned him quickly. Wouldn't you have a stronger argument?
Of course I'd have a stronger argument, but I got to play the hand that I'm dealt.
I appreciate that.
I will say one other thing, and that is I want to harken back real quick in my minute and a half to my contract argument, which is that the $75,000 was a liquidated damages amount, that if it doesn't show up, we're going to hit you for $75,000. But, Arizona case law recognizes that, hey, a liquidated damage clause is only valid to the extent that it's reasonable, and if you're going to bang somebody for the entire $75,000
But this isn't
when he's here.
This isn't a contract to supply cardboard boxes. This is a contract in a criminal case to get you to show up, and its whole purpose is to provide an incentive in an inherently penal environment. Isn't that different from a normal contract analysis?
This court has recognized that bond matters are contractual in nature, and I am just taking that argument to the next logical step. Whether this court wants to accept that argument, I hope it does, but candidly, I understand if it says, I don't know that we're prepared to go that far. Totally understandable. I would disagree, but,
Do you have anything that would support the argument that, every other judge in this circumstance would have imposed something or would have forfeited less than the entire amount? It's a persuasive. It seems like a persuasive factor, but I don't know how it gets us there.
Let me just say this: I did attach, and it is the only minute order that I could find of a decision where the defendant was brought back and the court forfeited the transportation costs. And there have been more rulings than the one I have supplied to the court. And that ruling is consistent, unfortunately, not with an Arizona Supreme or Court of Appeals case, but with a New Mexico Supreme Court case, State versus Amador, which is in my brief, where the Supreme Court of New Mexico found an abuse of discretion when the guy is locked up, I think also in Texas, and the bondsman said, look, I'll pay to get him back. And the state said, no, we want all 10 grand. And the court forfeited all 10 grand. And then the Supreme Court of New Mexico says, no, that's an abuse of discretion because, the bondsman did everything he could do. He's not going to bust him out of a Texas hoosgow, but, he's going to get him back here. And so to forfeit the entire amount of the bond is an abuse of discretion. Would I like that to be Arizona law? You bet your life. Could this case be that? Sure could. Am I encouraging the court to do that? You betcha. I've run out of time, but obviously I would answer any questions the court has if it has any more.
We appreciate both of your arguments. Thank you. We will take the matter under advisement at this point and issue a written decision in due course. The court will also stand in recess to allow the next case to set up.